Hi, good morning, everyone. Um, my name is Naledi Morojele from the South African Human Rights Commission. I'll be your moderator for today's launch. Um, I think we are going to get started now. Um, so, once again, good morning. On behalf of the South African Human Rights Commission, I want to welcome everyone to this virtual launch of the Commission's report into the sewage problem that has been polluting the Vaal River in the Emfuleni area. Before we begin, I'd just like us to cover some housekeeping that we have to do with these virtual engagements. I just want to ask those who are not um, on the panel to please switch off your cameras, and also please make sure you mute your microphone for the duration of this launch for about an hour or so, unless you are one of the speakers who is speaking. Um, for this hour for the launch, we will not be taking any comments or questions, but please do stay for the webinar immediately afterwards, because there will be more opportunity for engagement and questions and comments. However, if there's something extremely pressing that you would like to address, please do use the chat box. And if time allows at the end, then I will read that out. So thank you. Um, so, as the South African Human Rights Commission, I want to thank you again for availing yourselves for this important session discussing the gross human rights violations in areas within the Emfuleni local municipality. Uh, During this launch for the next hour, we'll be sharing with you the reasons why the Commission initiated an inquiry into this particular sewage problem. And most importantly, for the first time, we are now announcing our findings from this inquiry, as well as what measures the Commission recommends be done to mitigate the conditions under which people in the affected areas live. And just for the purposes of the report and the launch and the webinar, the name of the Vaal will collectively refer to the Vaal River, the dam, the barrage, and the Rietspruit. And also, for those who would like to read the comprehensive report, please be aware that it is available on the official South African Human Rights Commission's website for download. And also, just a reminder once again that immediately subsequent to this launch, there will be a webinar where we will be discussing the inquiry and the report in more detail. So before we get into the actual report itself, I will be providing a brief background explanation of the inquiry that was undertaken. And then after that, Mr. Buan Jones, who is the provincial manager of the Commission's Gauteng Province office, which undertook the inquiry, will then present the final findings that have been made. And then our Commissioner, Jonas Rangoni, will then be taking us through the recommendations that have been made in the report. So during the period of July and August of 2018, the South African Human Rights Commission received reports that raw sewage had been leaking into and polluting the Vaal for months. In addition to that, there were also media reports that stated that the main sewers in Thundervale Park were blocked, that raw sewage was flowing into people's yards and properties, and that raw sewage had been left flowing directly into the Vaal due to issues of mismanagement by the Emfuleni authorities. It was reported that the Vaal River, which provides a major source of water for the Gauteng province, had reached crisis levels as raw sewage continued to spill onto the land and into the river, which posed a huge threat to the drinking water of some 45% of Gauteng's population. So following these reports, the Commission's Gauteng Provincial Office then conducted an inspection in loco at certain sites within the Emfuleni local municipality. And what was observed from this inspection was, firstly, there was raw sewage flowing in a small stream that cut across the Emfuleni Gulf estate. I also observed there were two burst sewage pipes on the banks of the Rietspruit that runs through the Emfuleni local municipal area. We also found defective biofilters at the Rietspruit wastewater treatment works. A clogged sewage manhole was found at the Sharpeville Cemetery, and children were found swimming and playing there. And lastly, children were also found consuming this polluted water in the area of the school, the local school. So having observed these 5 violations of human rights in the Emfuleni municipal areas, and acting within the legislative mandate of the Commission, we thereby established a formal inquiry subsequent to this inspection. The purpose of the inquiry was to ascertain the extent and the consequences of the human rights violations in that area, the causes of the violations, the persons and the state or private actors who would be responsible, and whether the sewage spillage into the Vaal constituted a disaster as defined in the Disaster Management Act of 2002, and as well as to determine the various accountability, disciplinary and/or prosecution mechanisms which could be implemented against the persons or the entities that would be found to be responsible. The inquiry also then sought to understand the appropriate recourses or remedies within the powers of the Commission that could be given to effect, promote, respect, and protect the human rights of the people in the Emfuleni area, as well as provide just and equitable relief for any violations that would be determined. For the inquiry itself, oral and written submissions were presented to and received by the Commission's inquiry panel. Submissions were received from a wide range of stakeholders in the form of local, national, and provincial government actors, organs of state, nonprofit organizations, ratepayers associations, academia, as well as private sector engineers. And all of this information through the submissions was then presented during the inquiry and then was then assessed against our domestic legal framework and also against regional and international legal frameworks. And so now I would like to hand over to Mr. Buang Jones, who will then take us through the findings that were made from the inquiry and can be found in the report. Thank you.
Thank you, Program Director. I will now read the findings of the South African Human Rights Commission. Based on the research and submissions made by participants which included the national, provincial, and local government, civil society, community leaders, research and academic institutions, the Commission makes the following findings. The impact of the discharge occurring over more than 5 years violates a number of constitutional rights, which includes the rights to human dignity, freedom and security of the person, the right to an environment that is not harmful to health or well-being, the right not to be deprived of property, the right to health care, the right to food, right to water and social security, just administrative action, and the rights of children to be protected from maltreatment and degradation. The inquiry panel notes the submission that the Vaal River system supplies water to millions of South Africans. 19 million people depend on the Vaal for water for domestic and commercial use. The Commission accepts that the Vaal River is polluted beyond acceptable standards, and it became common cause during the inquiry that the cause is the kiloliters of untreated sewage entering the Vaal River. The Commission finds that the pollution of the Vaal River reverses the gains made from the Lesotho Highlands Water Project, a vital but costly project for the South African government. The Commission finds that the inoperative and dilapidated wastewater treatment plants have been unable to manage the treatment of the sewage and wastewater produced that the treatment plants can service. As a result, raw sewage flowed not only into the Vaal, but also onto residential streets, schools, homes, and other public areas in the jurisdiction of the Emfuleni local municipality. The Commission finds that the pollution is impacting natural ecosystems directly dependent on the water and surrounding wetlands, which form a vital part of the ecosystem. The population of yellowfish peculiar to a few South African rivers, such as the Vaal, are under threat of extinction on account of the change to the balance of the river flora and other competing species in the river caused by the pollution of the Vaal River. In addition, livestock which consume water from the Vaal and direct human consumption itself adversely impacts the health of consumers. In respect of the flow of raw sewage on public streets, paths, and into homes, the Commission finds that this poses a major health hazard to people and therefore their rights to dignity as well. In addition, and apart from the long-term effects of pollution of the water resource on life, are the direct concerns relating to the negative impact of the pollution has had on the economy of the Vaal region. The evidence provided to the inquiry panel regarding the decrease in tourist and recreational activities on the river is accepted. In respect of the domestic legal framework relating to the environment, water services, sanitation, all legislation providing for accountability or accountability mechanisms, the Commission accepts that the general concerns that the Commission accepts the general concern that accountability mechanisms may not have been invoked or given effect to by the relevant regulator and the Emfuleni local municipality. In terms of the Commission's assessment, the Water Services Act creates a clear responsibility on the municipality to provide water supply services and sanitation services to its customers living in informal and informal settlements. The municipality did not dispute this responsibility or that it had not fulfilled the responsibility, but instead it considered that these failures were attributable to its failing wastewater infrastructure. In addition to not providing water supply services, the municipality has, by not maintaining the water sanitation infrastructure, caused sewage pollution of the Vaal and in the streets and homes of persons living in the Emfuleni municipal area. This occurred in contravention of the National Water Act and the National Environmental Management Act. Despite having the ability to do so, it did not appear to the Commission that the Department of Water and Sanitation and the Department of Environmental Affairs, Forestry and Fisheries had been able to hold the municipality accountable for causing sewage pollution as required in terms of Section 19 of the National Water Act and Section 28, subsection 2 of the National Environmental Management Act. The pollution, in fact, continued for a number of years without being successfully contained. There were several deviations concerning contract management which posed serious risks for the municipality and service delivery recipients. Such risks arose in respect of contracts with service providers, choices made in the appointment of appropriate service providers, and the actual delivery by service providers, which has affected the management of wastewater corrective actions. In certain instances, the Commission was advised that contracts concluded by the municipality with service providers were not honored despite the provisions of Section 116 of the Municipal Finance Management Act, which requires that a contract entered into with a service provider includes terms for termination in the case of non-performance or underperformance. Where full delivery was not achieved to the standard required to address the problems in wastewater management and infrastructure, such contracts ought not to be accepted or paid. Alternatively, where contracts were entered into, a municipality has a common law right to cancel the contract and claim damages for breach of contract. The Emfuleni municipality had a responsibility to enforce controls and oversight to check its spend of public funds in the interest of delivery. The municipality did not provide any evidence of termination or claim for breach where service providers did not deliver. This amounted to another avenue of wastage of resources. To add to the dismal form of the municipality presented to the inquiry panel, the Commission was made aware that the municipality owes billions of rents to rent water for bulk water provision. While the Gauteng Provincial Treasury detailed that in relation to the growing outstanding rent water bulk account, the municipality has been on many previous occasions been assisted by the Gauteng Provincial Treasury working together with the Department of Cooperative Governance and Traditional Affairs. Despite efforts made by the Gauteng Provincial Treasury and Gauteng COGTA, the municipality did not service and honor the repayment arrangements established, causing the arrangement to lapse and become nullified. However, the Gauteng Provincial Treasury advised the Commission that with the continued Section 139 constitutional intervention in the Emfuleni municipality introduced in 2018, negotiations to establish a payment plan with rent water remain ongoing. Lastly, several submissions informed the Commission of a lack of skills within the municipality to effectively manage the challenges that had been identified in respect of wastewater management more than 10 years ago. However, according to private engineer submissions, the necessary skills are available in South Africa. The Commission finds that it is the responsibility of the Emfuleni municipality to, in accordance with the Municipal Systems Act and the Municipal Structures Act, to appoint skilled workers and or develop capacity for employees to be able to provide the necessary services. I thank you.
Okay, thank you very much, Mr. Buang Jones, the Provincial Manager for the Commission's Gauteng Provincial Office. I would now like to invite the Commission's Commissioner Jonas Banyoni to please take us through the recommendations that the Commission has made from this inquiry. Thank you, Commissioner.
Thank you, Program Director, Naledi Marujele, and good morning to everybody who is connected. I'm going to say that based on the findings and the domestic legal framework, the Commission made the following recommendations, or I would regard them as the directives. Given the situation, there is a need both urgent and comprehensive intervention in and above current Section 139 of the Constitution's intervention by the Gauteng province. The Commission's recommendations include recommending the following points. There are 14 of them. Number one, that the national, provincial, and local government to take active steps to know and understand all of its constitutional and legislative obligations and to comply and implement them as is the duty of any public servant or municipal administrator. Number two, the municipality uphold the rule of law and constitutional supremacy in South Africa. And thirdly, in the short term, that the Department of Water and Sanitation, or the Gauteng COGTA, that is Cooperative Governance and Traditional Affairs, together with experienced wastewater management specialists and respective treasury departments, draw up a cost-effective interim plan to urgently stop or limit the flow of sewage in the streets and homes of people living in the Emfuleni area and also in the Vaal. Fourthly, the national and provincial governments, for the medium and long term, conduct a detailed needs assessment for the cleanup and rehabilitation of the Vaal. Such an assessment should be supported by experts, including financial experts, to cost and make available a project plan and budget for the implementation of such plan on a short, medium, and long-term basis. This includes the Department of Water and Sanitation and or Gauteng COGTA, engaging with experienced wastewater specialists for job specifications to be drawn up in order to employ or contract the necessary skilled people to repair and replace the defective sewage systems in the Emfuleni municipality. Fifthly, Department of Water and Sanitation develop and implement policies and standards to deal with water crisis in South Africa and the contamination of the Vaal River in particular. And sixthly, vandalism and theft be regularly reported to the South African Police Services, that is the police. The Department of Water and Sanitation consider placing private security guards at the sewage infrastructure to prevent further vandalism and theft. And number 7, the Department of Water and Sanitation reintroduce blue and green drop transparent quality measuring system. Number 8, the Department of Water and Sanitation collaborate with the Department of Environmental, Fisheries and Forestry and use the inspectors provided by the National Environmental Management Act, that is the NEMA, to investigate offenses relating to water and sanitation as they are likely to relate environmental damage. Number 9, in order to prevent a repeat of the issues, the Vaal River and the associated water infrastructure be declared as critical infrastructure as per the Critical Infrastructure Act number 8 of 2019 or 2019, declaring the Vaal and the respective sewage systems as critical infrastructure would ensure that it will be protected and restored. Number 10, municipal councils develop mechanisms to interact with communities and identify service needs and priorities. Without capacity to strategize, integrate, and interface with non-municipal groups, many local governments are unlikely to be sustainable in the future. The implementation of new strategies and policies requires strong municipal leadership with the necessary support and belief of the municipal council. Continuous communications between all role players and regular oversight and training should be provided and encouraged. Number 11, regular inspections of the Vaal and regular meetings to report on all of the above to take place between respondents and the Commission. And number 12, the Human Rights Commission would like to reiterate that no evidence was put before it in order for the Commission to make a finding on it, who, when, and or why existing legislation was not given effect to. The Commission should, however, like to request a renewed or continued commitment to accountability and to ensure were not already implemented. Public servants and municipal administrators and staff who failed to comply with their obligations under the Public Service Act or the Public Service Act, yes, and the Municipal Systems Act and the Municipal Framework Management Act, and contributed to the disintegration of the municipality, be disciplined or dismissed in accordance with the PSA and the MSA. And labor relations legislation, the PSA and the MSA set out a lengthy list of responsibilities for public servants and municipal staff. These obligations are a minimum duty on government through its officials to render mandated services to the public in an effective, efficient, and economically cost-effective manner. Effective performance management requires vigilance over the quality of delivery of development to build and strengthen the public service. Performance management also requires that municipal staff who do not give effect to their obligations experience the consequences of repeated poor delivery, such as dismissed if warranted. In the absence of stringent consequence management, the public purse is impacted and constitutional duties flouted while people continue to live in deteriorating conditions. Any irregular or fruitless and wasteful expenditure be investigated and the relevant parties be made to repay monies to the municipality, and that where applicable, the actions be reported to the South African Police Services in terms of Section 32 of the MFMA. Any accounting officer, political office bearer, or municipal official who deliberately or negligently made or authorized irregular expenditure or fruitless and wasteful expenditure is liable for that expenditure. A municipality must recover unauthorized, irregular, or fruitless and wasteful expenditure from the person liable for that expenditure. Any allegations of corruption be referred to the public protector or the police. In terms of Section 32, subsection 6, an accounting officer of a municipality must report all cases of irregular expenditure that constitute a criminal offense to the police. Where the charge is against the accounting officer, the municipal council must report the alleged offense to the police. Where contracts are not being honored, that the municipality or its administrator institutes legal action in terms of the MFMA to cancel the contract or to, under common law, institute legal actions for breach of contract and claim damages. Alternatively, claim lost money under unjustified enrichment. This is a general need to create precedent that municipalities or that communities to service providers that they will be held accountable. Number 13, the Commission is hereby notifying the national, provincial, and local governments that the sewage problem is a crisis and an obvious liability to the state. The consequences of the pollution could result in a string of legitimate civil claims against the Department of Water and Sanitation for damages as provided in the NWA, the National Water Act. And in addition, failure to implement the Water Services Act, the NWA, and the NEMA in respect of water and sanitation and pollution of the Vaal area will result in further litigation that could escalate all the way up to the Constitutional Court. Section 151 of the NWA makes the intentional or negligent commission of any act or omission which pollutes or is likely to pollute a water resource unlawful and a statutory offense which carries penalties. Where harm, loss of damage caused by the offense for which a person was convicted is proved in water court, the person or persons who suffered harm, loss, or damage may be awarded pecuniary damages. And lastly, number 14, the Commission also recommends that in terms of Section 139, subsection 7 of the Constitution of the Republic of South Africa, Act number 108 of 1996, the Commission is recommending, and also on Section 63 of the WSA and Section 19 and 63 of the NWA, Cabinet seriously consider taking a decision for national government to intervene in the running of the Emfuleni local municipality. I want to emphasize this, that the Commission also recommends that in terms of Section 139, subsection 7 of the Constitution and Section 63 of the WSA and Sections 19 and 63 of the NWA, the Cabinet seriously consider taking a decision for national government to intervene in the running of Emfuleni local municipality. The failure to repair and replace the sewage systems of the municipality is not only failure or a failure to comply with the WSA, but it is a failure to many people over many years to properly run the municipality. Program Director, it is proposed that all departments of the municipality, save for once the provincial and national government can show is operating adequately. I thank you.
Right. Thank you very much, Commissioner. That was Commissioner Sibanyoni from the South African Human Rights Commission. I see that it is just after 9:30. I wonder, Guang, will the webinar start immediately after this, or will it start at 10 as scheduled?
The webinar starts at 10, and for now we can wrap up, but I should also hasten to add that the national, provincial, and local governments have a period of 60 days within which to respond to the Commission on its findings and recommendations. Thank you.
All right, thank you very much, Buang. So the webinar will be starting at 10, as you indicated, and in the chat box, I've just added the link. The webinar will be taking place on a different link from this one. So please check the chat box to access that link. Okay, so thank you, everyone. We'll be closing this section, the launch. In closing, we'd like to, as a Human Rights Commission, we'd like to thank the various media outlets that have joined us today. You know, the media plays a very important role for the Commission and human rights in general in the country in terms of identifying and reporting violations. But in this instance, it's also playing an indispensable role in terms of helping to get the findings of the Commission's inquiry out to the broader public and to those communities that are directly affected. We would also like to extend our gratitude to the many individuals, organizations, forums, government and state actors that made submissions to the inquiry. There are many of them, so I won't name them all, but of course the comprehensive list can be found in the report itself. Remember, the report is available on the Human Rights Commission website. So we would like to thank everyone who participated, who cooperated with the inquiry, and also made very valuable input. And lastly, we'd like to thank the staff of the Human Rights Commission who assisted in making the inquiry possible. We'd also like to thank our leadership, which includes our COO, Chantal Kisun, our CEO, Tiso Chipanyani, and of course our Commissioner, Commissioner Suanyoni, for their leadership in this inquiry. So thank you very much once again, and we hope that you will stay and join us for the webinar that will be starting at 10 o'clock.